Good afternoon. Welcome to the Appellate Division, First Department. As I call the calendar today, please ask for the time that you actually need. And remember that if the panel has additional questions past the time you've been allotted, we'll ask them, and you'll have an opportunity to answer. We read your papers and are familiar with the issues that underlie your appeals. For those of you here for the first time, you should know that the white light on the lectern will go off when you have 2 minutes left, or if you've asked for less than 2 minutes, it will go on immediately. When I call your case, rise, and please let me know who you represent and how much time you are requesting. People v. Christopher Walls.
Respondent request 4, Your Honor.
5 and 2 and 4. U.S. Bank v. Chait.
Good afternoon. For the appellant, Robert Bling, Gallo Associates, we request
5 minutes and any rebuttal?
5 minutes.
Okay, 5 minutes, you got it. Yes?
Request 5 minutes.
5 and 5.
Thank you very much.
AM Children is submitted. Miracle New York Properties versus Nebar 18.
Appellant, 4 losses. And suspect for respondent, 7 minutes.
4 and 1 and 4. People versus Kirby Hisiano. Submitted. Singer v. de Blasio. Justice Gonzalez is recused on that matter. Let's begin with the appellant. You want 15 and 8? Okay, you're not getting that. What would you guys like? Yeah, that's fine. I was thinking I would give you all equal amounts of time, perhaps 3 or 4 minutes. But if you wish to have someone speak at greater length, that's okay. You can just reallocate among yourselves. Okay? Everybody wants 3? Very good. Oh, I'm sorry? Okay. So we'll go with 6 and 2 and 3 and 3 and 3 and 3 and 3. Thank you. People v. Kevin Davis. 5 and 1 and 5. 268 West 12th Owners Corp v. Kunst.
Appellant, 7 and 2. Respondent, appellant, 6 and 2.
I'll give you 5 and 2 and 5. People v. Chacona Wood. Submitted. People v. Lazarus P. Submitted. Reyes v. City of New York is submitted. Metropolitan Partners v. Nerney is submitted. Step up on People v. Walls. Please.
Good afternoon, Your Honors, and may it please the Court, and Kekshi Arandu from Center for Appellate Litigation for Christopher Walls. The police had no probable cause to stop Mr. Walls and the other passengers in the car because there was no VTL violation.
The car was double parked.
Right, and did any of the exceptions to the prohibition on double parking obtain here? Do we have any evidence in the record that they were discharging passengers, for example?
So the car actually was temporarily stopped to let out passengers. There was all the evidence pointed to the fact that the car was temporarily stopped.
But is that an inference, counsel, that we can draw from the evidence?
Well,
How do you draw that inference?
the car lights were on. It was a fully loaded car, so they were carpooling essentially. The engine was running, and the police saw the car for seconds. Under my adversary's
20 seconds.
less than 20 seconds. So seconds. And
I thought they testified to 20 seconds. And I mean, the case law really, do you have any cases that might give us some kind of temporal proximity that we can start? What's the baseline? Is there a baseline?
Sure. So in People versus Bonilla, which is a First Department case, the cops testified to driving around, seeing a car that was temporarily stopped, and then drove around the block and saw the car that was still there. So
That car was stopped in a bus stop for minutes.
okay. So
right?
and then in People versus Williams, the police actually asked the driver to move the car repeatedly, and the driver refused to do so. And so what we're saying here is that under my
Counsel, here there was, what was this, one lane in each direction, right?
yes.
And there were they ambulances or fire trucks on one side of the street at one point? Looking at the video that was given to us as part of the exhibits, it seemed like it was quite difficult to navigate the street. So if a car is double parked, isn't that a problem?
So what we're saying here is that seconds was just simply not enough time to actually know that the car is not temporarily stopped.
So did People v. Bonilla and People v. Williams state that it has to be seconds or more than seconds, 20 minutes? Did it give us a time frame in those case laws?
No, but there has to be some indicia that it's actually stopped. It's actually stopped to in violation of the VTL.
Well, if no one gets out of the vehicle or no one enters the vehicle, does that meet the exception of the VTL case? Because we can agree that in the VTL 1202, I think it is, that double parking is not permitted, right? We can agree on that.
So no, I don't agree that double parking cannot be categorically impermissible. It wouldn't make any sense. Every Uber driver that lets out passengers.
Right, because then we
constantly-
have exceptions for loading and unloading passengers. And so now
Exactly.
I'm asking you, in this particular fact pattern, for those 20 seconds, was there any loading or unloading? Did anybody enter or did anybody leave? Or were they just in the car?
Our argument is that there wasn't enough time. Seconds is just not enough time. You could imagine a scenario where you're saying your goodbyes to the people in the car.
But
Maybe
the
you're
VTO
looking for.
doesn't account for goodbyes.
So, but our argument is that the VTO cannot be categorically impermissible to double park. There has to be some indication.
Counsel, the surveillance tapes that are part of the record show the vehicle in question there for a while before the, again, I don't remember if they were fire vehicles, I don't think they were fire trucks or ambulances, whatever they were. They had flashing lights, they were on the left side. There was a point where there were no flashing light vehicles on the left side of the picture, and other tapes show where they pull up, and there's movement. So what was the totality of the videotape? What length of time was encompassed by those tapes?
That information was not in front of the hearing court. What we know is that the police testified, and that's what I'm directing the court to really zero in on. The police testified to only seeing the car for seconds. Our argument is the simple one. Seconds is not enough time to adequately know that a car is double parked versus temporarily stopped to let out passengers. If it truly was the case that it was categorically impermissible, carpooling would be prohibited by the VTL, essentially. You could never stop your car to let someone out.
Thank you, counsel. You have time in rebuttal.
Good afternoon, and may it please the court. Reva Grace Phillips for the respondent.
So, counsel, in those cases cited by your adversary, Bonilla and Williams, we have something else other than just a double parked car, right? We have several minutes in a bus stop in Bonilla. We have, in Williams, instructions from the officers to move the car, and then they didn't move the car. And even going in further in the Wale case, there was items in plain view when the officers approached. But we don't even need to get that far, right? Because how long does it take for someone to get in and out of a car? I mean, the VTL is silent as to that. And so what is reasonable? We have some basis in those other two cases. But I mean, honestly, if somebody is in a car for 20 seconds, even if we were to accept that as true, is that not unreasonable to think that they were unloading or loading?
So having heard Your Honor's questions, I think clearly temporality is the key question to this case. And there is no temporality requirement to find a violation for double parking. It is categorically impermissible to double park in New York. VTL subsection 1202A2, which is what counsel's relying heavily on, allows for the temporary pausing of a car to discharge or accept passengers. but it's around specified locations that would make inherent sense. So that includes fire stations, intersections, locations where the curb is accessible, so it's been cut down to allow, for instance, a wheelchair to move up or down. So I think that the fact that these two sections exist side by side actually evinces not only a plain text intent to distinguish them, but a legislative intent to say there are locations where you can stop and discharge a passenger. They're these specified ones.
Was there any testimony that there was a driveway or a crosswalk?
No.
Those are some of the exceptions.
Correct, Your Honor. There was no testimony. It was uncontroverted testimony from the officers that this car was double parked. It was parked beside a lane of parked cars. That was also supported by photographic evidence. There is no need to read some temporality requirement into the VTL. The
Is anybody getting out of the car?
No, Your
according
Honor,
to the
and
testimony?
No, Your Honor, absolutely not. And you know, obviously we can't look to the trial testimony to bolster the hearing, but I think it's clear why defendant didn't elect to put on any evidence at the hearing. Because at trial, defendant testified that he was idling in the car for at least 2 minutes before the officers appeared because he was waiting for someone to come down from an apartment. So even by defendant's own admission at trial, he wasn't temporarily stopped to get out of the car real fast with his cousin. He was there waiting for his cousin's girlfriend to come down so he could talk to her and ostensibly get back in the car before leaving.
But that would that be load-in passengers?
Well, Your Honor, I think that would be double parking, and it would be double parking in violation of the VTL because defendant didn't intend to merely get in or out of the car, for instance, as an Uber driver would, or as someone carpooling might. But that evinces, again, the fact that this was a double parked car. It was impermissibly double parked, authorizing the officers to approach, where they then observed in plain view one of the 3 loaded firearms recovered from this car. Additionally, I would just note the defendant's sentence is...
Well, those other two, I mean, you mentioned, no one's mentioned the other 2 firearms, but one he was acquitted on and the other one was suppressed after the hearing. So we're really only talking about one here.
Yes, Your Honor, though he, again, at trial elected to raise the suppressed firearm as a part of his strategy to argue that the officers were lying. That contention was rejected correctly by the suppression hearing, facing uncontroverted and corroborated testimony from the officers. It was rejected by a jury of his peers at trial, and this court should reject it for the same reasons. There's no reason to read temporality into this VTL violation, and unless Your Honors have any other questions, I'll sit. Thank you.
Thank you, counsel.
Your Honors, the statute commands what New York drivers and common sense know to be true. It can't be the case that you can never stop your car to let out or pick up passengers.
Do you agree with your adversary, with counsel for the people, that there's no temporality in the statute? It doesn't say you can't be double parked for X. It's just plain and simple. Unless you meet one of these exceptions and you double park, you've violated the VTL.
But the definitions of standing and parking explicitly carve out exceptions for temporarily stopping to discharge passengers.
Does it also add specific locations, as your adversary asserts?
So 1202A does. 1200, which is the basic rules, explicitly defines what standing and parking means. So when a car is standing, or if a car is in a no standing zone, there have to be exceptions for when you are picking up or letting out passengers. And again, we just know this has to be true. Otherwise, virtually millions of drivers in a city like New York where parking...
Counsel, the problem is that there's no evidence that there was any passenger coming in or leaving. There was only a representation that the driver was waiting for someone to come downstairs. So how far does that get you?
That wasn't in front of the suppression court, so my adversary brought up that fact. That wasn't in front of the suppression court. What we do know...
Does that help you or hurt you?
We just know that the cops saw the car for seconds. That's what we know. And that's what I continue to harp on, that because seconds just can't be enough time. Yes, there's nothing in the statute that says, okay, like after 20 seconds we can definitively decide, but we know from common sense, and the legislature knew that there needed to be an exception to this rule. So we respectfully ask this court to suppress the gun, dismiss the indictment, and vacate the sentence. Thank you.
Thank you, counsel. Thank you both.
Thank you, Your Honors.
U.S. Bank v. Chait.
Good afternoon, Your Honors. My name is Robert Link, and I represent the plaintiff, Appellant U.S. Bank. All right, so today, after oral arguments, I'm going to go back to Woodlawn in the Bronx, and I'm either going to take the Metro North or I'm going to take the number 4 train. Similarly, with a motion to renew, you can file a motion to renew before the time to appeal expires, or you can file it before there's an entry of final judgment. This court just upheld that principle 1 week ago in the case of Bank of New York Mellon against Bosboom. In that case, in dealing with a foreclosure FAPA case, the defendant raised the FAPA defense after the time to
Does that contradict Plotch then? Bank of,
It's Bank of New York Mellon v. Bosboom, and I'll give you the citation
no,
on that.
but there's another case that's cited in the papers, Bank of New York v. Adam Plotch, LLC. Does that, because that case seems to run athwart what you're saying right now.
I believe the Plotch case dealt with an appeal and the timeliness of an appeal. In the Bosboom, which was just a week ago, and that's the reason why it's not in my papers, if you look at 2025 New York Slip Opinion 02866, again, just a week ago. But this is a long-standing principle. It was dealt with this court in Fife, it was referenced. You have the opportunity of one or the other. It's not necessarily the time in which a timely appeal can be filed.
So I don't understand you. Put aside the Bronx example because I began picturing all the trains.
Sure.
Okay. We have a 2015 action. It's dismissed in 2002, right? And
2022.
2022, sorry. And notice of entry is served on the 27th of 2022. So you don't move to renew until January of 2024. How could that possibly be timely?
It's timely because, again, the statute, if you look at the plain language of the statute, a motion to renew is timely before judgment is entered. In the facts of this case, a judgment was uploaded in NICEF and never signed by the court. It sat out there for all this time.
So you're saying you don't have 30 days?
You have 30 days, but that applies to the appeal timeline. That doesn't apply to the motion to renew. The motion to renew for change of law is out there because we want to make sure the court has every opportunity to get things right. And in this case, the law went back and forth like a seesaw, right?
Counsel,
Go ahead.
Can you just give me that citation one more time?
That citation is 2025 New York Slip Opinion 02866. And again, the law kept going back and forth and back and forth. Your 1304 notices were valid. We had summary judgment. Then we had judgment of foreclosure and sale. Then we went up to this court, and this court told us, go back and do a hearing on the amounts due and owing. We did a hearing on the amounts due and owing. We went and made another judgment of foreclosure and sale motion. But this time, the second department intervened with the Kessler decision and rendered our notices invalid. So then we bring another case, and in that time period, the Court of Appeals changes what the second department did. So I think what a big picture view should be taken of what's going on here. The law should not be a moving target. And that is exactly what the motion to renew based on change in law is about. We need the timeline to make the motion and allow the court to get it right. Here, there's no question that we've presented the facts to be entitled to a judgment of foreclosure and sale.
Is your 2022 action, the one you filed in 2022, is it still viable?
It's still pending. And what we did here to avoid the 1301 issue was to have two competing actions at one time. Before we move forward with a motion to renew, we moved for a stay in the 2022 action. We said we don't want to have two competing actions at one time, so we want to move for a stay. The court declined the stay, and then we just went ahead and filed the motion to renew based on change in law. That was rejected, and then we renewed that decision, and that was rejected. Those are the three appeals. I would imagine if appellant plaintiff is not successful today, we'll be here another day on the 22 action and whether or not that in fact is valid. You know, so that's where we've been. I see that I'm out of time. Thank you.
Thank you, Counsel.
Good afternoon, Your Honors. Daniel H. Richland, Richland & Falkowski, PLLC. I'm the attorney for defendant Mindy Chait. I think Your Honors are quite correct. The question of how could this possibly be timely, you are correct. It is not timely. It is not timely because the rule my learned colleague...
Are you familiar with the Bank of New York Mellon case that was cited by your opponent?
I am not offhand. I can only explain what I know of the rule, which I believe is not changed by that case that I have not read. What I understand of the rule is that you have two time periods. First, you can bring a renewal motion before you have a final order or judgment. And what that means is something that finally disposes of a case. Anything left outstanding, if there's any non-ministerial matter left outstanding, there's still the potential rightness for a motion to renew. The alternative is if you're timed to appeal. It's not one versus the other being the end period, it's both. And the problem here is that both were complied with. If you take a look, the final dismissal in the 2014 action in 2022 left nothing left for the court to do. That is why they brought a new action.
So you're saying that the entry of judgment was just a ministerial act?
The entry of judgment was a ministerial act. Well, I would say the entry of a judgment would have been a ministerial act. Yes.
Because the order disposed of the entire matter.
Exactly, correct. And the court found that when it said, this judgment is redundant and I'm not signing it because you already have full and complete relief.
And you did move to enter judgment, correct?
Exactly, yes, right. I'm not quite clear what my client could have done more timely to have gotten the relief that they're saying we didn't get. Because when we asked and the court said, you don't need this, that seems the end of the matter. Should I have appealed that to Your Honors and said, Your Honors, this is obviously incorrect. The court says I don't need this relief, and maybe in the future there will be a renewal motion 18 months later, and I need to protect my client against that. Please reverse this and direct entry of judgment. Or would you say that the dismissal order was final and complete? Because it was. There was nothing left. If there had been something left, why did they commence the 2022 action? They commenced it because they decided there was nothing left. This is a new action. And if you consider what will happen here, if my learned colleague is correct, you're going to create a 1301 problem on the subsequent application I will get to make, right? Because I get to choose which of these two actions I want to defend. And I think Your Honors can tell I do not want to defend this action. I would prefer to defend the 2022 action. So I will be moving under 1301 immediately if my learned colleague is granted relief to dismiss that action, which will be granted and then appealed. And then you'll get it again. And you'll say, unfortunately, we have to affirm it because you can't
That's
have
what
two.
we're here for, counsel, for appeals.
Exactly.
We'll be okay.
Exactly. But I'm saying that's just the outer continuation of this. I do think the timeliness, though, that's the problem.
A year and 3 months.
Exactly. After commencing a new action, too, as well.
And when they moved to stay the 2022 action, they had yet to file the motion to renew.
Yet another problem, correct. Yes. What can I say? Your Honors know the record better than I do, I'm sure. You understand what the actual problem here is. Are there any other questions for me?
Apparently not. Thanks, Counsel.
Thank you very much.
Thank you both.
Counsel,
Counsel, you didn't ask for a rebuttal.
Sorry, I
did
asked
you?
for a 5-minute rebuttal. I thought I did.
I thought you were asking for 5 minutes in total. That's what I was telling you. Usually we don't ask for 5 and 5, but I'll give you 2 minutes.
A minute, if you don't mind.
well, I actually do have a question. What was left for the court to do after that September 26th entered on 27th order? What was left, other than the ministerial act?
Well, I mean, I think that there's a significant estoppel problem by counsel arguing before this court that the judgment was ministerial. It didn't mean anything, but if you look at the record at page 310, on document 239 of NICEF, Mr. Falkowski filed a judgment to the county clerk, proposed. So either it was something that was supposed to be done and it was something pending before the court,
But that the
or
court
it wasn't.
didn't, is that the judgment that the court declined to sign?
That was the judgment that the court declined to sign years later on May 25th, 2023. And just to refer to Your Honor's point about why we didn't move.
I don't think you answered my question, though.
I'm sorry, I thought I did, but my apologies. I'm worried about the time.
So you're
Go
saying that there was nothing left for them to do, or what was left to do?
It
'Cause
was
in order,
to enter judgment as the statute, CPLR 2221, directs. It says the time in which you can make a motion to renew based on change of law runs on the entry of judgment. That is the clear
but
case law articulated by
if
this
the
court.
order effectively was the judgment, because there was nothing else left to do, and I still haven't heard you tell me what was left to do, then why isn't it running from that day?
Because the statute directs, number one, that's the plain language of the statute, but in a judgment, hypothetically, attorney's fees could be awarded, the judgment could be docketed against a block and lot. They're different uses of a judgment as opposed to a decision in
I
order.
believe that the only thing they wanted was a document that said that the action was dismissed. Isn't that what they wanted? The
They
defense?
wanted a judgment that it would be
That
dismissed.
it was dismissed.
Right, and they
that's what the order said.
They took affirmative steps to go ahead and put that judgment, a proposed judgment, before the judge on September 30th, 2020.
But that's what the order said, that the foreclosure action was dismissed.
Right, and then the judgment that counsel put up for signature was never signed. But
Because it basically said the same thing. The action is dismissed. So that's why the court said it's redundant.
No, I think a judgment has different operations than a decision in order. A judgment could be docketed against the block and lot. A judgment is going to appear in the title records. A judgment has different mechanisms than a mere decision in order.
I understand, but the court found it redundant and said, you don't need this.
Right,
The
and I
action-
believe
The action
that-
is dismissed.
And I believe that that was incorrect because of the statute 2221, which specifically says it's the entry of judgment that's important. And this principle was just upheld by this court a week ago with respect to a defendant in a FAPA case. But just to respond to Your Honor's point briefly, I wanted to get about that. This is
You're
not.
trying to avoid noncompliance with Section 1301, and that's why you didn't move to stay. Moved to renew when you moved to stay.
And
I
our
read your
motion-
briefs, counsel.
Okay, and the motion was attached as an exhibit.
But
We were
1301
asking for leave, and the actual motion to renew
Counsel,
was-
but 1301 in reality did not apply because you didn't get a judgment, they got a judgment. And 1301 refers to a final judgment for the plaintiff, not for the defendant.
That's correct, but we're saying
Right.
1301 wouldn't apply in our facts for a number of circumstances, including that version of 1301. First of all, we moved for a stay and were denied, but also the version of FAPA that counsel is alluded to wasn't in effect until after we'd commenced the case. And with that, thank you, Your Honors. Thank you for
Thank you, counsel. Thank
enjoying
you
that.
both. Miracle New York One Properties versus Nebar, 18. Please.
Good afternoon, Your Honors. Despite the law with regard to time of the essence declarations being extremely well established, Supreme Court determined that the respondent in this case declared time of the essence by using what one commentator called conditional language. So what are we talking about? We're talking about a letter that specifically says, and I'll just quote it because it's a short sentence, in the event the transaction does not close by December 11th, our client will not abide by any further delay, and the security deposit will be forfeited. So the language we're looking at—
Why is that not clear, distinct, and unequivocal?
Well, because it says by, and the use of the term, I know, I understand, but if you look at what the Court of Appeals says, the Court of Appeals in ADC Orange Corp said the term no later than is insufficient to declare time of the essence.
Counsel, what about the time of the essence language in the demand, which said closing and sale by 7/20/23, time is of the essence?
That was superseded by adjournment transactions. They're in the record. So that's time of
So
the essence was-
and then that was followed up by October 30th, 2023, all conditions to
Correct.
the closing have been met. There was a representation, condo approval was secured, and then it was said, closing by November 10th, time is of the essence.
Correct. Well, that wouldn't be no good anyway because it uses the same language by, but it was, those closings were eventually adjourned until—
Right, so, and the adjournments were substantial, and they were because—
Correct.
Why?
They were because of
Your
this—
client needed additional time to get the financing and condo approval,
It was
correct?
the condo was essentially
Right.
causing a—
So as to the extensions, in 2023, there were extensions given the closing dates were adjourned. So there were extensions received to February 1st, July 20th, November 10th, November 30th, December 8th, and finally, December 11th was the
Correct.
final one. So is it your position that every extension had to say time is of the essence?
100%. Because
Really?
yeah, that's the law. Once you go past the time of the essence date with the consent of the other party, you have to set a new time of the essence date. Those old time of the essence dates are no longer valid. Otherwise, you never need to declare time
So
of the
it
essence.
sounds like a gotcha argument.
It is, but so says the Court of Appeals, and so says, the Court of Appeals says you cannot use the word language by a specific date. There is no difference between no later than or by. The second department, in two cases from 2002 to 1987, says an on or before date.
Do we really follow the second
No,
department?
but I'm just there, okay, but there's no court that says this type of conditional language is
Counsel, the
acceptable.
purchase agreement, it didn't contain a financing contingency clause, right?
That's correct.
Okay.
So the last thing I would say, and there's a recent case that came down from March from the Western District of New York, which you don't obviously don't have to follow, but follows along the same lines, citing ADC Orange, which is the Court of Appeals language case, saying that language said, despite must be finished by. That was a
But
construction.
in ADC Orange, there was no time of the essence language in prior communications, unlike
Irrelevant.
here.
That doesn't matter.
Really?
That's the law, and I'd be happy to send
Really?
you a letter showing that.
I have
prior
to say,
time
I
of
was
the
also-
essence
Counsel, don't talk over Judge Gonzalez. She doesn't need my help, but it's really bad practice.
Thank you, counsel. Thank you. I was really interested by the extension that was requested on, what was it, November 29th of 2023. The closing was scheduled the next day for December 30th, and the reason for the extension, for the need for an extension was because of Thanksgiving, but Thanksgiving had already happened like 6 days
Yeah, because-
earlier. So your argument is that even though you received accommodations, time is of the essence language had to be included each time, even though your client was a beneficiary.
That's correct. That's what the law says. It's crystal clear. You must declare time of the essence correctly after you allow a time of the essence date to go by, move on by consent.
Thank you, Counsel. You have time to rebuttal.
Good afternoon, I'm Ken Sussman, and I represent respondent in this action.
What's your view of the ADC case? Does it stand for the rigid proposition that?
It doesn't stand for either of the propositions, which he's conflating language required in a contract to be a time of the essence clause, and in that situation, the law is clear. The contract itself must say time of the essence. In a subsequent default, the cases are very clear. There's numerous cases. No specific language is required. Absolutely, the case law says time of the essence language is not required in the default. That's in the first department, it's in all the departments. And the second thing he conflates is this notion that ADC stands for the proposition that it must say on a specific date rather than by. ADC is a clear case. It's a contract. It was a contract where there was no time of the essence clause, and there was never a default notice sent. There was a letter that's sent that says your down payment is due on or before December 31st, and I hope that you'll make this payment on time. That's certainly not a time of the essence letter. A time of the essence letter must give equivocal notice, a reasonable time to close, and must state that the consequences of failure to close. ADC case doesn't even approach that. There was never even a default notice. Our default notice is on par with all of the law. We said you must close. We agreed to a closing on December 8th. That was a specific date. It was the date requested. It's a reasonable date because it's the date that the purchaser requested.
And you also put them on notice that failure to abide by that date would constitute a default.
We left room for this argument because we ostensibly gave them a grace and said, if you don't close by the 11th, you'll forfeit. What the lower court didn't address is what we think is well-settled New York law, that a purchaser without breach on the part of the seller defaults on a real estate contract without lawful excuse, he simply cannot recover his down payment. We cite the Rivera case in the First Department, which is directly on point, and there was a buyer who was not willing and able to close. And in that situation, the court said we never addressed the sufficiency of the time of the essence letter, which in that case was
Counsel,
insufficient.
let's anticipate the notice argument that may come up. Was notice on counsel, Ms. Jacobson, was that enough?
It was. The law is also clear, and counsel, I don't think can contest it, that where notice was actually received and there's no argument of any prejudice, the notice provision of the contract doesn't have to be strictly enforced. In this case, there's no doubt it was received. It was.
And Ms. Jacobson was on the email chains involving these adjournments, right? And she was a lawyer who was hired by, was part of the firm. I don't know if she was a partner or not, but she was an employee of the firm.
It was sent to the lawyer who had been handling this, who wasn't on the notice. Both parties, both attorneys knew it. There had been, as the court pointed out, there had been a series of time of the essence letters, and there was never any argument of any prejudice.
One question as to the date of commencement of this action, which was December 22nd of 2023. That was the same date, am I right, when defendant conceded that it had no ability whatsoever to close?
That's right. That's right. At that point, it had been made very clear, and it's clear from the papers, that the reason they didn't close is because they lost their financing. For whatever reason, they just told us they didn't have the money. In the papers, there's this discussion where they asked us if we would be their partners. We had waited 15 months for a closing. We'd gone through the series of time of essence letters, and they simply didn't have the money to close it.
Thank you, counsel.
Thank you, Your Honor.
First off, there's no distinction between a contract, that the language that has to be used in a contract itself, and a time of the essence declaration. So ADC Orange is the determination that it was not a sufficient time of the essence declaration is exactly on fours with a notice that's sent by mail. There's no distinction between a contract and a notice. That's number one. Number two, that you can't even get to the issue of a default until a time of the essence has been declared correctly. The Court of Appeals has said that if time of the essence isn't declared correctly, and I know this is going to sound crazy, you get an indefinite adjournment, that the closing is adjourned indefinitely and time. There's one case from the Second Department that the closing was adjourned like 3 years as a result of an incorrect notice of default.
What say you then of the language in several communications that unless there was a closing by a certain date, the deposit would be forfeited?
Mm-hmm. Well, the problem is that language, as one commentator calls it, conditional. By is not acceptable. It has to be a specific date and time. There's one court that says you got to say where you're going to go and how you're going to do it in the time period. Most time of the essence defaults are done by you show up at a closing, you tender a deed to the court reporter, they mark it as an exhibit. None of that happened here, but we don't even need to get there. The issue with regard to that December 8th date, we didn't say we were going to close on December 8th. If you look at the email, I think it's contained in the record of page 150.
We can do that, counsel. Thank you very much. Singer v. Bill de Blasio.
Oh, I'm recused on that.
You are.
Yes.
As I said before, Justice Gonzalez is recused on this case. Please.
Good afternoon, Your Honors. May it please the court. From the outset, I'd like to stress the following, which may seem obvious upon reading our papers, which is neither the court below nor this court is being asked to decide the merits of this case. It's just being asked to decide whether the pleadings, as amended, which are stated in the second amended complaint, which was proposed to the lower court, and which incorporates the respondent's own admissions.
Right, we're
and
aware of that, counsel.
communications.
Let's talk about your RICO claim, your civil RICO claim. So
Yes, Judge.
how is the predicate behavior spelled out? Because it seems to me it only deals with EVCC's use of email and wires to file taxes. And I don't see how any other defendants are mixed up in that. So unpack that for me and tell me where it is in the complaint, which I have in front of me. It's like a doorstop.
Judge, I apologize. Just a moment.
Or you don't have to cite chapter and verse, but just tell me, like, what is
Right, well, as Your
the
Honor,
predicate behavior?
As Your Honor correctly observed, the EVCC entity was created as a not-for-profit entity, which has certain tax advantages, and it's not permitted for them to use the mails, use interstate commerce, or otherwise take advantage of those tax benefits when the entity itself is being funded by Mr. Sosnick and Mr. Rosen almost exclusively, and they're reporting otherwise to the federal government.
So tell me how that leads to a RICO claim.
Well, that forms the basis, among others, of the predicate acts that would lead to,
So you spoke about Mr. Rosen. Was he, and you call him in your brief a party, but he's not a party yet, right? Was he a party under the First Amendment complaint?
I believe, Your Honor, he was added
He was
as a
named?
part. He was, I believe, Your Honor, was a named party.
Okay. Please continue. Predicate act.
Right. So essentially by utilizing those, by engaging in those predicate acts, they were impermissibly seeking to essentially acquire my client's building unlawfully. And as is more fully set forth in the Second Amendment complaint, which,
By allegedly misrepresenting what, where their donations came from in their tax?
I'm sorry, Judge?
By allegedly, they were taking over your building by allegedly misrepresenting where their donations came from, allegedly?
They were utilizing EVCC as an agent.
No, I know your whole theory is sort of they're like this AstroTurf organization, that they're in fact funded by Mr. Rose and
Right.
Mr. Sosnick. I know that, but I mean, just, again, how does this make out predicate behavior under RICO? Or if you want to move on to another cause of action, that's fine. I don't hear the RICO. I'm
Well, Ju-
sorry.
Well, Judge, then Judge, I'll rely on my papers in connection with your request.
Okay.
Now we'll move on to the other causes of action, which include breach of contract. I mean, my clients were deeded this property by the city, okay, and they were specifically
Breach of contract or interference with contract?
breach of good faith and fair dealing, which is a breach of contract claim, Your Honor.
Okay.
And they were specifically interfered with by the city and made to essentially not comply. They were not afforded the fruits of the bargain because they weren't enabled by the city to develop the property.
How
in the way
does
sought.
our decision in the case that was decided in 2022, when we heard another appeal
Right.
from you, how does that affect this particular?
The biggest difference is that in 2022, we weren't aware of all of the additional discovery that was disclosed subsequent to the appeal. So this court essentially held that a lot of the allegations were conclusory or speculative. Well, we filled in those blanks, and
And that there were discretionary acts that were taking place.
right. So the discretionary acts, it turns out, weren't discretionary at all, by virtue of the fact that the city has subsequently admitted that the requirements that my clients comply with the institutional nexus and the dorm rule, they weren't actually requirements at all with respect to this building. And that happened in December of 2023 when my clients moved to supplement their pleadings. And the argument in response was, the dorm rule doesn't apply here, which was shocking because all along, my clients, the city was using this as a means to revoke the permits that had already been issued. And so, frankly, it was a ministerial act for the court, for the DOB to sign off on the permit and issue it once again, or rather withdraw the revocation, okay? And there's additional testimony that we obtained, which said that but for City Hall's interference, the DOB would have issued the permit. In other words, City Hall had no discretion here, and neither did the DOB for that matter. The City Hall shouldn't have been involved in this process at all. This was something for the DOB to issue, and they did multiple times. And the only reason why it kept being revoked is because of all of the allegations that we made in the second amended complaint. Again, it's an as-of-right property. And even City Hall's, even the Director of Legislative Affairs, in emails to other city government officials, admitted that they don't have any authority here. That's their words. We don't have any authority here in emails. We should make it clear on background. It's a privately owned site with an as-of-right use, and our options are limited. Nevertheless, they pressed ahead. And based on all the additional allegations that we're making, which again, incorporate the city's and the other defendants and respondents' own communications, the second amended complaint is well pled. It states all of the claims asserted, and the court should reverse the trial court's decision.
Thank you, counsel. You have time, rebuttal.
Good afternoon, Your Honors. May it please the court, Diana Lawless on behalf of the city defendants. Your Honor,
Okay, so the point that counsel just made about the dorm rule being waived or changed for Class B buildings, which is what this building is, I take it. How does that play out here?
well, I don't think it plays out into any way. I think, I would say the easiest thing is that this is the law of the case from the court's prior decisions that the plaintiff can't seek damages from anything to do with the permit denial. And this is about the ruling of this court, and the prior appeal was about immunity, about a discretionary act, and that the proper vehicle is Article 78.
Can only be challenged through an Article 78. You make that point
Right.
very well.
But I think the issue is that what he's saying is that I do not think there was any admission at all, because where this came up was there was a second proposed supplemental pleading that came after this proposed second amended complaint, where they alleged things about an investigation that they took on several years later about how other properties were given approvals to build a dorm, and they claim that the city said in response that the dorm rule didn't apply to those properties. But there's not an admission there, there's nothing in there that has to do with this proposed amended complaint. But I think even if there was a problem with what he's saying, we're like, well, the city said that it didn't apply, and it should have applied, and it should not have applied. It doesn't matter for the purpose of a discretionary act, because if there's discretionary governmental immunity, the Court of Appeals has held that even if it's wrong, that's what an immunity does, right? It's like if you could be liable for something, you are immune because of the nature of your act. That's what the Court of Appeals has held. So even if it was wrong, even the Court of Appeals has held, even if it's malicious, you still have discretionary.
There's no tort liability arising from it.
Absolutely. There's no tort liability arising because of the act. And the Court of Appeals, I'll point out, I don't think my adversary said this, the Court of Appeals has said very clearly, I believe it's the 17 Vista Associates case, the grant or denial of a permit is a discretionary act by the government. So that's clear, and that all flows from the prior decision. I know my adversary is talking about all these new things they found. I know Justice Pitt Burke was on the prior appeal. It's all the same nature of the same thing about the different kinds of corruption and the different kinds of things that this court already rejected.
How many times has this been rejected already?
This complaint?
Well, the allegations that the plaintiffs putting.
Well, I think, well, these allegations, this will be the second time to this court, already in the federal district court, and then two prior state court actions, and then a
What
original
happened in the
action.
bankruptcy court, too? Weren't these raised as an affirmative complaint? In the
Right, I think they
bankruptcy?
tried to remove it to the bankruptcy court, and then it was,
There was no ruling on the merits of the
I
bankruptcy.
do not think there was a ruling on the merits. It went back and forth. So we've been through this many, many, many times, and because this court ruled prior that there was immunity and that the underlying claims involves allegations, the DOB exceeded its jurisdiction and violated lawful procedure, which is exactly what they're claiming. All of the remaining state law claims, which is nuisance, good faith and fair dealing, and prima facie tort, arise from the same permit denial, and that there cannot be, the complaint cannot be amended. The complaint is futile. And just Your Honor mentioned RICO. I will just note that what my adversary was saying about this scheme, this enterprise about mail fraud, wire fraud, the only municipal person that could be held liable is former Mayor Bill de Blasio, and I will note that in their brief, all they claim is that some statements that Bill de Blasio made were some of the injuries that the enterprise induced, so he's not part of the enterprise no matter what, even if there is one.
Thank you.
Thank you, Your Honor. We ask that you affirm.
please.
Charles Dorkey of Denton's US for EVCC and Aaron Sosnick. A couple things. One, Michael Rosen's never been a defendant. Two, there was no decision on the merits in the bankruptcy court. The court, we
You want to talk about Nora Pennington?
on Nora Pennington, we believe Nora Pennington immunizes our action in this case, both under the state law claims, under the RICO claim. I mean, it's pretty clear that that's,
They'd have to make out a sham objection in their pleading, right?
beg your pardon?
They'd have to make out a sham
Yes.
exception in the pleading.
I think if you look at their allegations against us, and I direct your attention to Judge Gardefee's opinion, 2022 Westlaw 453-6818 at 3, he goes through so-called newly discovered evidence that was put forward to him. It includes lobbying activities. It includes using charities to hide the personal agenda. It goes to Mayor de Blasio's statements, and it goes to Mr. Sosnick's interest in buying the building, which gets to your point about the sham exception. You can't have a sham exception. One, if you're ultimately successful, the law says that there can't be a sham, and we were ultimately successful. But two, it also is the case that if the party has a legitimate personal interest, and there are cases that talk about the interest of being a co-owner, being a neighbor in a community.
Sure,
That's
that's
enough
covered
of
by
personal interest, and it's
Right.
not like your sole interest is to hurt Mr. Singer.
Right.
And his damages flow from the fact that since 2008, he had to comply with the dorm rule, and he never complied with the dorm rule. Thank you, Your Honor.
Thank you. Hold on, counsel, I gotta give you more time. 3 minutes, right?
Yes.
Very well.
Good afternoon, Your Honors. Elise Schindel from London Fisher on behalf of George Arts Communications. My client is a lobbying firm. I was prepared to speak about our.
You also talk in your brief about not having any nexus to any kind of enterprise whatsoever. You want to talk about that?
Well, Your Honor, the three remaining causes of action against my client are nuisance, a claim for nuisance, a claim for RICO, and tortious interference with prospective business advantage. The second amended complaint does not adequately plead any of those causes of action against my client. There is no nexus. We are clearly a lobbying firm, and any actions, if plaintiff could ultimately prove any of them, would be covered by the Nor-Pennington Act. This court already looked at the allegations and the factual allegations that were alleged against my client in the original complaint, and this court found that the Nor-Pennington Act applied and that there was immunity. This went back to the trial court. The trial court made the same finding based on this court's findings, and also found that any new allegations that were in this second amended complaint, again, did not rise to the level of coming close to forming any viable causes of actions against my client. As to these three causes of actions, these new facts and allegations stem from its identical alleged underlying whole scheme that's alleged in this action, which, again, do not apply to my client, and also would not, if anything does ultimately come to being applicable to my client, would be covered by the Nor-Pennington Doctrine, and immunity would apply. And so, if Your Honors do not have any further questions, I will cede my time.
Thank you, counsel.
Good afternoon. May it please the court, Megan Brown on behalf of the respondent Paul Wolf. I don't want to repeat everything that's already been said.
Mr. Wolf's line of work is he's a real estate agent, and he's in the complaint he's alleged to be sort of a front for Mr. Sosnick. But what is his actual day-to-day? What's his employment?
He was acting here in sort of I guess a lobbying capacity. I know that has.
Is he a real estate agent, or did I misstate that? I'm sorry.
sorry?
Is he a real estate agent, or am I misstating that?
I believe so, yes.
Oh, okay.
Yes. And the point I want to make with respect to Mr. Wolf is all of the conduct that is alleged with respect to this proposed second amended complaint is the exact same conduct that was alleged in the first complaint and the first amended complaint. It's that email, hey, I have somebody who might be interested. We can get, that email is attached to the complaint that was before this court and decided in the 2023 decision. Nothing about Mr. Wolf's immunity-clad actions can give rise to a new complaint against Mr. Wolf. This is all the same conduct that this court already said was immune. He's not part of any sort of underlying
Criminal
predicate
enterprise.
acts for the RICO. He's just not part of it, as you already pointed out. He's barely mentioned in the briefs, frankly. And I really would draw this court's attention to the Kaufman case that this court decided in 2024. And I believe it's in my brief, and the site is 224 83rd 500, where this court already addressed the issue of a repackaging of previously dismissed causes of action with increasing conspiratorial claims that can't be substantiated. This is exactly the same procedural position we're in here, and just like in that case, I would respectfully request that the court affirm.
Right. In your original brief, you said that this was a regurgitation of the same arguments, and also it was window dressing, added window dressing to previous allegations. Didn't you write that in your brief?
I don't remember saying window dressing. It sounds like something I might have said, so
Okay.
I'll go with it.
No big.
I like it. I'll take it.
All right. Thank you very much,
Thank you.
counsel. Any questions for counsel? No. Thank you. Please.
Please the court. Rise Aqui for HRNA advisors. So in addition to the arguments, preceded by my fellow respondents here, unique to HRNA advisors is the fact that we have been dismissed from this case since February of 2023. We were dismissed for plaintiff's failure to timely file for default judgment. Judge Borok's order from February 2nd, 2023 specifically bars plaintiff from refiling this lawsuit by way of amending the complaint. Again, this order has been upheld. Plaintiff has never challenged this order. Again, it's well established by numerous court decisions that you cannot amend a complaint when there is no complaint to amend, such as the case here. Again, plaintiff is attempting to bring back HRNA advisors into this lawsuit improperly.
But your primary argument is that they didn't timely move for a motion to hold you in default, or they didn't timely move for a judgment of default, and so therefore they are foreclosed by Judge Borok's previous decision
That's correct.
from suing you any further.
That's correct.
Okay. Anything else? No, unless you want to add anything, counsel, I don't want to stop you.
No further additions, Your Honor.
Thank you. Okay, I think that's it for them. You have 2 minutes, counsel.
Thank you, Judge. Judge, this case isn't about a denial of a permit. The respondents were merely using that as a means to accomplish their overall goal of depriving my client of his rightful use of his property as of right use. We've stated claims 5 in the second amended complaint, which incorporates all of the additional information we obtained since the original appeal back in 2023. And that includes their own admission that the dorm rule never applied to my client's case. End of story, never applied to my client's building. With respect to the second amended complaint itself, it incorporates over 100 pages and I think over 300 separate paragraphs and allegations that substantiate the claims asserted, along with the supplemental pleadings and the motion for summary judgment, which incorporates the fact that the city never applied the dorm rule in this fashion against any other building except my client's old building. If you take that together with everything else that we've asserted in this complaint, I think we clearly state a claim here, and we should be allowed to pursue those claims at the trial level. The remaining arguments regarding Norr Pennington, obviously it can't be used as a sham. It can't be used to facilitate corruption. At the end of the day, it can't be denied that $50 million was offered as a means of buying back this building from my client. I don't know how much more corrupt you can get than making such an offer in connection with everything else that was going on here. So the bottom line is, this did not have to be brought as an Article 78 proceeding, and it couldn't have been, because all the claims could not have been stated, and my client is not seeking injunctive relief here, and he's seeking at this point, because at this point Sosnick owns the building, money damages in the form asserted in the amended complaint, the second amended complaint. Thank you.
Thank you, counsel. Thank you all. v. Kevin Davis.
Okay.
Hold on one second, counsel.
Yeah.
Please.
Good afternoon, Your Honors. Victorian Wu, Office of the Appellate Defender for Kevin Davis. The 44020 motion should have been granted because the imposition of 1 year of interim probation rendered the subsequent 5-year term of probation illegal. Specifically, by
So you're saying that when he was sentenced to 5 years probation, that was illegal. That means that that probation could not have been revoked by the court.
That's correct, Your Honor. The moment,
Therefore, he should not have been sentenced to 2 1/3 to 7
that is correct, Your Honor. The
for having
moment-
violated that conditions of probation.
that is correct, Your Honor.
And so let's say that we agree with you.
Yes.
What is it that we have to do?
You would have to vacate the sentence imposed in this case and remit the case to the trial court for further proceedings.
To be resentenced?
To be resentenced, but under Rodney E. as well, I think the Court of Appeals has explained that if the original promised sentence is illegal, then the defendant should be afforded the opportunity to withdraw the plea. And here the promised sentence was illegal because the combination of 1 year of interim probation plus 5 years of probation that was promised and imposed, collectively required Mr. Davis to serve 6 years of probation. That is in excess of the statutory maximum allowed by the legislature. And so because the original promise cannot be lawfully kept, Mr. Davis should be afforded the opportunity to withdraw from the plea.
Rodney E., of course, is somewhat distinguishable because the violation there was of the interim probation period, correct?
So it
I mean,
is,
just factually, that's correct, right?
that's correct, factually. But legally, it doesn't make a difference because here again, the court collectively required Mr. Davis to serve a total of 6 years of probation. So for that independent reason, the sentence here was illegal, right? Like the court ordered Mr. Davis to serve 1 year of interim probation, and after he successfully completed that, the court then ordered him to serve another 5 years.
The people concede that the interim probation was not authorized. They concede that in their brief. And so what they're saying is that he violated the 5-year period fairly quickly, about 1.5 years in, and so that makes it not a 6-year probationary period.
So that argument is incorrect, and I cited a second department case in my reply brief that illustrates that it doesn't matter when the defendant actually violates the illegal term of probation. Once the court ordered Mr. Davis to serve 5 years of probation, the moment that the court pronounced that sentence was illegal because it exceeded the maximum punishment authorized by the legislature. So it doesn't matter how long a defendant subsequently serves the illegal term of
It
probation.
was in excess of the statutory maximum.
Correct, Your Honor.
So had he been sentenced to the 1 year interim probation, and as a condition, instead of being offered 5 years probation, he would have been offered 1 year conditional discharge. Okay? And he violates the 1 year conditional discharge. And then the court imposes the 3.5 to 7. Would the same argument applies?
I think the analysis might have been different, but that's a different case, I think. You're correct that analysis there could be different. Here, the problem again is that the court in total required Mr. Davis to serve 6 years of probation.
The court did, but he did not. That's the thing. That's the argument that is being made, is that he did not serve 6 years of probation. He received the 5 years of probation because he complied with the interim probation, but 1 year into the 5 years of probation, he violated those conditions.
So counsel, I'm wondering if the argument just based upon Rodney E. would be that whenever there is, in this time period, whenever there was an imposition of interim probation, that in of itself is problematic, which is why we're here, right? Because it's not, because there have been subsequent cases where there was interim probation, but it was found that because there was no enhanced sentence, it didn't matter that the interim probation part had been a quote-unquote illegal requirement. Is that more so what you're saying, that just because he was on the interim probation that we have a serious issue here?
It's a combination of the fact that he was on interim probation. The court then ordered him to serve an additional 5 years of probation.
If he had ordered him to serve 3 years of probation, would that resolve the issue?
That would have resolved the issue, but I'm not sure that at the time 3 years of probation was legally authorized by the legislature. They set like a fixed number, 5 years, and by going above that, by ordering Mr. Davis to serve 6 years, and going to Your Honor's question, the problem is at the moment that the court ordered him to serve 5 years of probation, at that very moment, that sentence that was imposed was illegal because the court was thereby compelling Mr. Davis to serve 6 years of probation in total. So it doesn't matter how long Mr. Davis actually went on to serve that probation. The moment the court ordered that illegal sentence, the sentence was illegal and due to be vacated.
Counsel, at what point in time is the unlawful interim probation properly challenged? Because I'm looking at the timeline. So it's imposed in 1983. The sentence with the lawful 5 years probation is in 1983. We have the violation of the lawful probation in 1985, and the appeal has to do with the denial of a 440-20 motion in 2020. So at what point is the unlawful, I'm calling it unlawful, I'm just doing it, right? At what point should there have been a challenge to that? Or could there have been a challenge before Rodney in 1991?
There could have been a challenge, but an illegal sentence can be challenged by way of a CPL 440-20 motion, and there's no time limit for the filing of a 440-20 motion. And I think that reflects the legislature's decision that an illegal sentence should not be allowed to stand, and people should have as much time as they need to bring a challenge to a
So going back to my colleague's question about what remedy is it that you propose, we know that 440-20 says that the conviction, the underlying conviction, is untouchable. Are we agreed?
Yeah, so I think the relief that we're requesting is for this court to vacate the sentence and remit the case for further proceedings.
But what would those further proceedings be?
Right.
So at this time, I anticipate that Mr. Davis would probably seek to withdraw from the plea precisely because the original promised sentence of 5 years of probation, when combined with the additional year of interim probation, is illegal. So the court cannot keep an illegal promise, and therefore, under Rodney E., as the Court of Appeals has explained, a defendant should be permitted to withdraw the plea if the original promised sentence cannot be imposed.
Then resulting in a retrial?
Resulting in whatever proceedings might be appropriate in light of what the parties would like to do.
Okay, thank you, counsel. You have time on rebuttal.
Good afternoon, Your Honors, and may it please the court. Excuse me. Bridget White for the people.
So, counsel, if you would just continue this thread, if you would. What is the proper remedy under the circumstances? And was a challenge timely made, or does it make no difference when it's made?
Your Honor, I'm not aware of a time limit on defendant's ability to challenge the illegal sentence. However, certainly would have been in a different position and would have been able to resolve this in an easier manner. For example, if defendant had objected earlier, we could have simply struck a year of or removed the year from the probation. However, regardless, the defendant's ultimate sentence was within the permissible statutory range because he was sentenced to the statutorily authorized 5 years. The interim.
But I mean, that's, I guess, looking at it in a vacuum, because what do we do with that 1 year of interim probation, which we know, based upon Rodney E., was not permissible?
Well, Your Honor, even if we were to sort of credit that year towards that 5-year probation and sort of retroactively strike the last year of the probation, as argued in our brief, the defendant still would have been within the statutorily authorized 5 years when he committed the first-degree rape violating the probation. So ultimately, defendant wasn't prejudiced in any way by the illegal interim probation.
So the way I read Rodney E., I believe that the holding was an enhancement of the sentence because he violated the interim probation. And so that's not what we have here.
Right.
So because he did not violate the interim probation, he fully completed that.
That's right, Your Honor, and that's consistent with this court's opinion in People versus Vega, which I think read in conjunction with the other cases, clearly establishes that what the concern is an enhanced sentence based on the violation. And here, defendant really isn't entitled to a remedy because he wasn't sentenced to an enhanced term based on the illegal term. It was only based on the legal term that he was.
So then your position is that in reading Rodney E., we should disregard everything that the court says about interim probation not being permissible and only focus on what potential outcome can flow from that if there's an enhancement. Because it would seem to me impermissible is impermissible. And no matter how you slice it, I know in the subsequent cases, Vega, Mack, and I think that's it, those cases talk about enhancements. But isn't just the underlying premise that interim probation was impermissible?
Of course, Your Honor, and that's absolutely what Rodney E. holds. If we could, I think certainly we would not want to have subjected the defendant to that illegal term, but we can't unfortunately go back and fix that. And here, defendants wasn't actually prejudiced by that, so he really shouldn't be entitled to a remedy that that the law doesn't authorize. If Your Honors have no further questions, we would ask that you affirm. Thank you.
Thank you, counsel.
Just very quickly, Your Honors, I think there cannot be any dispute that the trial court cumulatively required Mr. Davis to serve 6 years of probation. That is, including the 1 year illegal
Did
interim
he
probation.
receive a sentence enhancement for a violation of the interim probation?
He did not, but here the distinction is immaterial because the sentence was illegal because it exceeded the
You're saying it's illegal because you're adding 5 years in 1 year, but the statute allowed for him to receive the 5 years probation. It's not as if the court somehow enhanced his sentence due to an interim probation violation. That's not what happened here. What happened here was that the court made him an offer of 5 years probation if he complied with the interim probation, which he did, and then he was sentenced to the 5 years probation.
Yes.
Which was a legal sentence at the time.
Well, I would respectfully disagree with that. It was not legal because the court, at the moment that it ordered Mr. Davis to serve 5 years of probation, cumulatively ordered him to serve 6 years of probation, and that is more punishment than the legislature has authorized the court to impose. And while the respondent says that there's no prejudice, the legislature has mandated and the courts have recognized that a legal sentence simply cannot stand. And for that reason, the sentence here must be vacated and the case remitted to the trial court for further proceedings. Thank you.
Thank you, counsel. Thank you both. Last case is 268 West 12th Owners Corp. Please.
Good afternoon, Your Honors. May it please the court. My name is James Halter, and I represent the respondents below and the appellants here, Andika Kunst and Blaine Bortnick. This is a case about the appropriate license fee for petitioners' 15-month repairs, which will require completely covering my client's townhouse, covering more than half of their backyard, covering their the portion of their front stoop. It'll involve people coming through their house from 8 a.m. to 5 p.m. It involves destroying their garden that they've been working on for 26 years. And this is all for petitioner's benefit. Petitioner needs to fix asbestos. Petitioner
Well, that's the nature of licenses, and that's why we have to have them, because we all live so close together in Manhattan.
Right, and that's why real property 881 exists.
So, counsel, there was a stipulation here back in July of 2023, right? And the issue of what the license fee would be was left for the court to decide. To what extent was the decision of the court appropriate, inappropriate, legal illegal, reasonable, or unreasonable? Take your pick.
There was only one piece of evidence before the trial court about what the appropriate license fee would be. It's a sworn statement by a contractor.
Did Mr. Bryan break out where he got his comparables from? Or he sort of stated these are the comparables, but did he say at this address we had this license fee or et cetera? He didn't do that, did he?
He did not. But this is petitioner's case. Petitioner had the burden here. About a year ago, this court told a respondent, somebody in a similar position to my clients, that they couldn't complain about the $4,500 monthly fee because they didn't submit proof in the court below about what the appropriate license fee would be. Here we've got the inverse. That was matter of 18 West 55th Street versus Pliati's house.
Right, but even going with that, I mean, we can still, both things can be true, right? In that particular case, they didn't present evidence to show what the appropriate license fee would be. But in this particular case, you know, to go along with the number that your person put out, 10,000 to 15,000, I think, how do we find that to be reasonable? And why is that an abuse of the court's discretion to have to, after hearing everything, to come up with the number that they did?
Not only 10,000 to 15,000, but to be paid up front.
It was not paid up front. It was be put in an escrow. According to Mr. Brioni, and I think only 30,000 was put in escrow, which is about 6 months of what the judge actually ordered. So not paid up front. This is basically we're valuing what the decrease in the value of my client's property would be.
Counsel, how was the end result reasonable or unreasonable?
It's unreasonable because we're covering his entire house. We're comparing what he could rent this house for, they could rent this house for per month versus what we could rent this house for if it was in a cave with no backyard and with no sunlight at all. What petitioner points to is, hey, look, there's some other cases where people got $100 a day for tearing up their backyards.
They offered $1 too, right?
Yes, so they started with $1.
We know that. But you still haven't answered my question. What formula? Is there a formula that the court should have followed below? Where do you stand?
I stand on it could be a real estate appraisal. It could be some sort of person who's done this before, like this is what we paid before. They could come and say, hey, we just did this for the neighbor on the other side. That's what the court ordered. That makes sense. Petitioner has that burden, and they never contradicted Mr. Brown's statement. Here, they make the incredulous statement that he's self-serving. I don't know how that is. He's not getting any portion of this license fee. But this is a substantial covering of the entire house for a very nice townhouse in the West Village.
But the backyard is an amenity, and it's an important amenity, but people can only use that during certain seasons of the year, correct?
Yes.
And what was the evidence also, and I have all respect for gardeners who are, because I know you can put your soul into a garden, but what was the evidence that the plants would necessarily die because of the scaffolding around them and the shade?
It was my clients provided affidavits about how they built this property and how the scaffolding is going to cover them. It covers almost all the gardens, but more than half the backyard, but particularly the garden area is going to be covered. It's 15 months without light. I don't think it's much speculation at all about the property. But
the scaffolding was going to envelop the building, or just the roof and the garden?
The scaffolding is going to completely cover the townhouse, more than half of the backyard and some of the front yard. The garden is not the entire backyard. The garden is some of the backyard, and particularly where the scaffolding is going to be.
Thank you, Counsel. You have time to rebuttal.
Thank you.
Good afternoon, Your Honors. May it please the court, Jeffrey Gangemi for the respondent appellant. I would first like to respectfully submit that the appellants have not met their burden to overturn.
Counsel, how should we take into account the bad blood between your client and the respondents? They say it went beyond friction, and they wanted that one individual, not Ms. Paniatu, to ever have to deal with them. So does that factor into this, that there was some bad faith? And also, Justice Gonzalez alluded to the fact of giving a $1 a day license, which is, to me, kind of insulting.
Well,
anyway, tell me, does that play into the judge's
Yes, Your Honor.
Because if there's been a history of bad blood, perhaps that will continue during the renovation, and therefore you want to protect the respondents whose property is being incurred upon.
Well, first, Your Honor, I would say as far as the bad blood, there's no conclusive evidence. These are just allegations that were made. There was no chance to respond. As I put in my reply brief, this petition was brought on by order to show cause. So the affidavits that were submitted in opposition, there was no chance to reply. There is in the record my letter to the court stating that even though there was no right to reply, that the allegations were rejected, but there was no way to reply.
History, your clients and his clients regarding unlicensed work done before? Isn't there some kind of friction between these parties?
Your Honor, to argue friction would be the party's self-serving interpretation of it, but at the end of the day, as Your Honor's pointed out earlier, that these are necessary repairs that are done, and there's a statute that addresses this because neighbors in New York City need to work together in order to...
So, counsel, the court in making their the ruling and it exercised discretion and came up with a number. Had you put forth any particular number that you were looking for, or you would have agreed to aside from the $1?
No, Your Honor. The $1, Your Honor, to give context, if you look at the chain of the emails, this was at the very, very beginning of the communications.
I mean, it doesn't really matter where it doesn't matter when it happened.
$3,000, Your Honor. $3,000 was put in the petition. That's what was being negotiated. That was what offered to the court.
$3,000 in total.
A month.
A month.
Yeah, a month. It was not $1. Quite frankly, it's disingenuous because the $1 was because the appellants asked for a written license agreement to see the scope of work. It was the very first document that was prepared. Way back, months and months and months before there were actually negotiations. The appellants are two attorneys, experienced attorneys, who were acting pro se, and there was just a draft of a document to show the scope of work. The petitioner was more than happy. No, we're not saying that the petitioner didn't want to pay anything, but $3,000 is what...
The parties gave the court the discretion to select a number as far as what the license fee would be per month, right?
Yes.
Why was that decision of the judge reasonable or unreasonable? And how do you counter, if you say that it was unreasonable, with what are you countering?
Well, I respectfully submit, Your Honor, it was unreasonable because the appellants asked repeatedly, they requested the $3,000, the $100 a day, $3,000. It was only until the case was started that all of a sudden, within 2 months, when they put in their opposition papers, this $10,500 to $15,000 came
Right.
out.
So that was their request at the time the case was pending before the court. According to your information, you guys came in somewhere around $3,000, and the court came in the middle of that, about $5,100 a month.
Yes.
Why is that not perfectly within the court's discretion?
Your Honor, respectfully, I think that in a case like this, a lower court case has stated it eloquently that parties under RPA PL 881 are allowed to negotiate in good faith, but they can't use the statute and the processes of the court to extract, a windfall from another party.
Are you answering the question? I mean, I'm waiting to hear an answer. The renovations are to the benefit of your client, yes?
Yes.
It's not because the brownstone needed the renovations. So they're going to lose light. They're going to lose the joy of their backyard. They're going to be in darkness for 15 months, including in the winter months, no sun. So where do you end up as far as a reasonable number?
Well, again, Your Honor, we rely on what the appellants, who also in their affidavits stated, was that they were consulting with contractors during the process. So if they came at $3,000 and they're the ones, they were offering $3,000, and then we actually commence an action.
That's before you gave it to the court to decide, yes?
Yes, Your Honor. But it just, again, our position respectfully is that this is what the appellants believe was satisfactory.
You could have said yes.
Yes.
Then you said, no, let the court decide.
Yes.
Okey doke.
I didn't address my other two arguments, my cross appeal. Can I have 1 minute just
You
to
got 30 seconds, Counsel.
Okay. There's just two other points. The court, in addition to the daily license fee of the $170 per day, the court also did a step up after the first 10 months, and that was again, we respectfully submit, was a punitively.
That escalated fee is unwarranted because there was no showing of, quote, an amplified diminution in the value of defendant's premises or a greater loss of enjoyment. How is time passing not a greater loss of enjoyment? That's time that they're not in their garden. We're all mortal, you know? So how is that not a diminution?
I appreciate, Your Honor, but $2 per day is just.
Oh, I'm just talking about going up to the 240 right now.
Again, even in my brief, you'll see that the petitioner again never said there shouldn't be some step up, but it had to be reasonable, not a $2 per day. It's even hard to even calculate every single day that goes by.
$60 a month.
Yeah, and then we continue on.
Is that a lot?
It is, Your Honor, considering that they're already starting with a baseline of over $8,000. So yes, over the course of the following months.
But we shouldn't even get to that, because based upon your estimates, this was 12 months worth of work, and that would not put you into the $2 a day as long as you stay on schedule.
Your Honor, there's so many factors involved with keeping on schedule. You have so many different things that can happen. You have weather, you have contractors who have issues. So yes, theoretically, if that's possible, that would be terrific, but there's no guarantee, and that's why we just built in this additional time. It's just, again, in our respectful opinion, we just don't believe it should be an escalated penalty where every day that goes by that the petitioner is, in fact, penalized. It just doesn't.
What percentage of the work has been completed?
Okay, none.
None?
There is an order to show cause for contempt that is pending. And we have not gotten access. I know counsel will argue, but there is an order to show cause for order of contempt that is pending.
Brought by whom?
Yeah, the Department of Buildings has issued a violation earlier this year.
No. Who brought who
the
moved?
petitioner.
Oh, you moved for
Yes.
contempt
Yes.
against them?
Yes.
Because they
Yes, we still haven't. This has been years. If you look at the record, they've been trying to get access for years. This case has been going on for 3 years, this petition alone. I negotiated myself personally, it's in the record, for 7 months before we had to commence this petition.
Are you paying the fee right now, the license fee?
No, because we have not gotten access.
Thank you, Counsel.
Let me address that. The Department of Buildings said they can't start. The Department of Buildings denied their permit, and they don't have the insurance that the court order required.
I'm sorry, the permit for what is denied?
They applied to the Department of Buildings to start the work here, and the Department of Buildings said no. We don't know why. They're supposed to reapply. We don't know. We don't know what's going on there or when it's going to happen.
So is $2 a day a penalty?
No, Your Honor. As time goes by, there's a lot of stuff that I could put up with for a day. There's a lot less stuff I could put up for a week. 15 months, there's actually very little I think I could put up with. As time goes by, things get more and more incrementally difficult to deal with. But I do want to address the history here. First, the petitioner said, we're not going to do a license at all. And then Mr. Gingemi sent my clients a letter and said, sign this license with $1 payment or we're going to go to litigation. There was a settlement conversation back then where my client came back and said, okay, how about $100 a day, which escalates to $500 a day, and then $1,000 a day after a certain number of months. That falls through, the settlements don't work, we end up in litigation. That's a settlement conversation that they can't use as evidence, but that's their only source of $3,000. First of all, I don't know what happened to the rest of it, because it wasn't just $100 a day, it was escalating. Now Mr. Gingemi says—
You had a contractor who gave an estimate, is that right?
Yes, it was a
John Bryan, $10,500 to $15,000 per month would be a reasonable range for a licensing fee? License fee.
Yes. At that point, the SSLP, the Site Safety Logistics Plan, was available. It wasn't available when the settlement negotiations were going on. There was a much more fulsome discussion about what was going to happen here. The license agreement, the $1 license agreement, said this project is not going to take longer than 6 months. Obviously, now we're talking about 15 months. A lot has changed, and when Mr. Brion got involved, and looked at, this is what's going to happen, this is what I've done this more than 100 times, this is the reasonable value, it's 10,500 to 50.
Is the scaffolding up presently?
There is some intrusion. They illegally put up this part of the scaffolding in the back. They put it on their property and stuck it 6 to 8 feet over my client's property.
You're not enshrouded, your client's property's not enveloped or whatever, the cocooned or whatever.
It is not in the full cocoon at this time.
All right, thank you, Counselor. Thank you both. You want to hear more?